Thank you very much, Mr. Chair, and thank you, members. I especially appreciate the sensitivity to the importance of this issue in the chamber. It's nice to actually have a second reading debate that comes off as a thoughtful, meaningful debate, and I appreciate that. I'm going to make three brief points. Had the opportunity to hear the bill in Judiciary yesterday. My first point is about process. My second point is about the fact that this bill doesn't actually get at the fundamental problem it seeks to resolve. My third point is really to raise some constitutional concerns that remain, that quite frankly are perhaps aggravated by this bill. To the process question, you've heard that red flag laws are not new. They've been around for years, decades in a couple of situations. My process concern is if they've been around for 12 years, why are we, on less than 24 hours notice, managing a bill through our General Assembly with less than a week to go in the session? I do not think that that is an appropriate way to advance such an important issue. So I object to the bill based simply on process. To the fundamental problem that this seeks to resolve, I do not think that, in fact, it will get there. The reality is we all believe, and I don't want to put words in your mouth, that would be unsanitary, but I believe we all understand that mental health is the issue that we are seeking to get at. But this particular bill starts off interacting and engaging in the questions of mental health and immediately migrates into a private property rights bill. It's about taking away dangerous tools, weapons, from an individual. The challenge is, should the warrant be executed, should the petition be processed, and should the weapons be sought and collected, if they are not all collected, or if other weapons remain available, or if other tools of destruction and threat remain available, we will have failed to address the fundamental issue. That is, the individual who has demonstrated the mental health break is still in that same circumstance, at large, in the challenging circumstances they already are, with the ability to seek other means of destruction and damage. Further, under this question of are we answering the fundamental issues that we seek to answer or not, I'm concerned, and raised the question in committee and hearings, that in fact the search warrant, the execution of this particular effort may in fact become a precipitating event, such as the precipitating event that we saw in the tragic case of Deputy Parrish. This effort to collect weapons, to take private property, may in fact, in and of itself, precipitate the event that we are seeking to avoid. And that's a fundamental error in the logic of this particular bill. And third, and most importantly, we all believe in the Constitution. We all defend the Constitution, because without that, we are nothing more than a noisy rabble. It is how we protect ourselves. It is how we preserve the hope of a better future for our families and for our children and grandchildren. Our district attorney, my district attorney from El Paso County, came up and testified and started out with kind of a lukewarm support that got a little more supportive as he testified through, but he, in the course of his testimony, raised 5 or 6 or 7 different potential amendments that he would say probably ought to be considered, would in fact make this bill better, might address some of the serious constitutional challenges that remain in this bill. So, for these 3 reasons, a failure of process when time was available to do this properly, because the logic path of this bill does not get to the resolution and solution we would hope it would get to, and because constitutional concerns of a very serious and very broad nature remain, I urge your no vote on this particular piece of legislation. I respect very much the sponsors for engaging on this very important issue, but I am sad to say I do not believe this particular piece of legislation gets us where we need to go.